everyone, welcome back. I am Denny, also known as the Lawyering Dietitian, and I am back with episode 2 of the Legal Bites. Now, some of y'all may be wondering, bro, why are you sitting on the floor? You right by the couch. But I feel more grounded on the floor. I don't know. I haven't carved out a space yet that has good lighting. I have a ring light, which I'm using today because I recorded too late for the natural light to hit my skin. I don't know. I'm trying to figure it out. All right, the floor is fine. But this is where we're at for right now. So, if you're not following me, follow me at Denny's Journey on Instagram, YouTube. I don't know. Don't really go to my Facebook because I need a social media manager, like someone who can post across all platforms. And I know they have things where you can do that, but like when I do that, when I try to connect it, I have to sit down with my social media one day and just really figure out why it's not cross promoting on my Denny's Journey page. But anyway, definitely Instagram, definitely YouTube. Those are the top 2 places where you'll find me. I'm trying to get on the tick of the talk, but I'm trying. That's all I can say. Anyway, also you're going to be seeing this on YouTube, so be sure to subscribe. If you're following me on Instagram, is that I this week decided to do a poll on Instagram, and I was just like, what do you guys want me to talk about? So the vote was a hot legal topic. I'm a little late, and when I say a little late, I mean like 2 weeks, so that's like late. But I thought it would tie into what I wanted to educate you guys about, because I am a lawyer licensed in 3 states, New York, New Jersey, and Illinois, but I am not your lawyer. I am a registered dietitian. I may be your dietitian. I don't know who's watching. So that I don't know. I may be your dietitian. But I also wanted to make sure to use this platform to educate people. So I figured I would use Shannon Sharpe's story to educate you guys. Okay. So for those who don't know, hey, I guess I'm not that late, period. I'm going to read just like a summary, child, because more than likely, about what happened with him and his. So he had a few settlements actually, and I can actually talk about both of them. But I want to start with the OnlyFans model settlement, right? So old girl sued him for $50 million. Now, I'm gonna have these educational moments. If you ever sue someone, you're supposed to sue for more than what you want, because you're likely not gonna get what you want. But you can't then, you can, but it's just harder to like ask for more later. Like you can end up getting more, like if you're suing and then you reserve the right to sue for like attorney's fees and stuff like that. That's a way to get more than your settlement amount, but just don't go crazy either. When I say don't go crazy, like don't sue someone for $50 million when they owe you $500. That's what I mean. But don't go crazy. But I guess, listen, the sky's the limit. Let the judge tell you no. Actually, that's my stance on it. So anyway, so old girl, and I'm gonna talk. I'm talking to y'all. I'm not in court, okay? But old girl, she sued Shannon Sharpe. Say that 5 times fast. For $50 million. So I'm not surprised at the amount. What an attorney is supposed to do, especially when it comes to like settlement amounts, he should be looking at like prior cases that are similar to yours to say like, okay, with these similar facts, this person was able to settle for this amount. Again, you can shoot for the stars, the sky's the limit, but because sometimes judges want to know, well, why are you asking for this amount? Show me, controlling case law. So that's, I would say, is a strong reason why I would try to, if I was representing someone in a settlement, I would try to find cases that would justify or support, again, legal precedent, meaning other judges have agreed that with these facts that this is a reasonable amount to settle for. I think it's important to look for that just to strengthen your argument, right? Okay, so this New York Times article dated July 18th, 2025, and updated July 19th, 2025. The Shannon Sharpe, a Hall of Fame tight end and media personality, has resolved a lawsuit in which his ex-girlfriend accused him of the R word, according to the woman's attorney. It says, after protracted and respectful negotiations, I am pleased to announce that we have reached a mutually agreed upon resolution. Busby wrote, all matters have now been addressed satisfactorily, and the matter is closed. The lawsuit will thus be dismissed with prejudice. Okay, so for those of you who don't know what that means, when you file a case and it's dismissed or withdrawn without prejudice, that means that, like, we didn't get into the weeds of the facts of the case. Like, nothing substantial was determined. Maybe it was dismissed on, like, a service technicality or something like that. But it just means that you're going to have to try again. That's what without prejudice means. So, and that means you could file again for the same, like, issue. But with prejudice means that you cannot file again for the same issue. So for her allegations of the R word, she would not be able to file against Shannon Sharpe. You know, they usually come up with some type of written settlement that would prevent her from, you know, she's agreeing to not sue him again for this issue, and maybe, I don't know, leave him alone. I don't know, whatever. But that's what with prejudice means. She can't file it again. So that means she got some money. Okay, here we go. It says that the article says a dismissal with prejudice means Sharpe's accuser cannot refile the same claim against him in the same Las Vegas court. No criminal charges were filed against Sharpe. See, I know what I'm talking about, period. But I'm going to break it down for y'all so y'all get it. You know what I'm saying? All right. So, Lord, let's see. Child goes on to give a little bit more details about the R word, when it happened, saying that it happened multiple times in their 2-year relationship. The suit further alleged that Sharpe was physically abusive, choking and hitting Doe, in addition to threatening her life multiple times. Again, I'm just reading the New York Times article. I am not agreeing with this or anything like that, because I don't know, I wasn't there. Again, just so we kind of know the background and what likely went on with settlement negotiations. So at first, Lord, Lanny Davis, Sharpe's attorney, when the case was filed, declined to comment. Busby's office has not responded to a request for comment. Davis, who's Shannon's attorney, previously said that Sharpe offered the woman $10 million before she filed the lawsuit, but she rejected it. So what does that mean? That means that she likely, some courts do prefer that you send, okay, courts are busy, right? Most courts, I should say. And when I say most courts, I mean, like, some smaller courts may have more time to hear more cases. But especially in, like, large cities like Vegas, like, I'm sure their courts are busy. So judges usually prefer that litigants, especially a petitioner or a plaintiff, the person bringing the lawsuit, handle that shit outside of court. That's what they want. So that usually is in the form of a demand letter saying, like, hey, I plan on filing suit. You know, a demand letter can, or like a cease and desist can say, hey, if you don't stop doing this, I'm then gonna file a lawsuit. They can include an amount, they cannot include an amount, it just kind of depends. But that's why she was offered money before filing the lawsuit, because they were trying to avoid the public knowing about it, you know, kind of like, I don't want to say hush money, but like, fine, you want some money, this is what we're offering, right? It clearly wasn't enough. Let's see, scrolling. Okay, that was pretty much it. So I have heard different amounts, like how much she's gotten. I don't think, when I was doing my research for this, I don't think any of those amounts that were said were confirmed. I think people were saying like 20 million, 25 million, something like that, y'all. Allegedly. Not sure how much she got. I do know that it was more than 10, because she clearly turned down the 10, so we could assume it was more than that. And if it was enough where the girl, she done went on Instagram and said she was retired or whatever. So that's where we are with that. Why? And then there was another lawsuit. Article is on Fox 32 Chicago, published August 7th, 2025. So this article says a $20 million defamation lawsuit filed by Chicago woman Jamalita Tillman against Shannon Sharpe, Chad Johnson, and their podcast team has been dismissed in federal court. The suit stems from an April podcast episode where Tillman was allegedly mischaracterized as being married and divorcing after a viral Usher concert moment, which she says was false and damaging. Tillman expressed satisfaction with resolving the matter, emphasizing a desire to move forward and recognizing both her and Sharpe's community contributions. Let's see the last paragraph of that article. It says Tillman also added that the incident negatively impacted her personal and professional life, including her role as director of the Harold Washington Cultural Center. Oh, I didn't know that. And her work in homeschooling advocacy. So I did not take a look at the lawsuit filing. She sued him and Chad and the team or whatever for defamation and libel. She said she came to a resolution. I did not know. So I used to live in Chicago because I went to law school at Northwestern. So that her being the director of, what was it again? The director of the Harold Washington Cultural Center is kind of crazy. Like in the sense that I'm sure when word got around, people knew who she was, especially, you know, being known in the community that place is on the South Side. Like, I'm pretty sure people know her name. I didn't really see I saw the clip now, but at the time, I don't remember her, like, specifically in that Usher moment, and I don't listen to Chad and Shannon, so I only hear, like, sound bites when they go viral. So, all right, teachable moment time. Okay, so let's talk about settlement. I'm going to use those cases to explain why things likely happened the way that they did. There are several reasons that Shannon Sharpe could have wanted to settle. One of them was that he was given a deadline by ESPN, not to settle necessarily, I would say handle the situation, whatever you want to call it. And I'm not saying they said that, but I'm also saying that I'm also saying that I'm not saying that they forced him to settle. So just like to handle the situation, deal with the situation. So another New York Times article dated July 30th, 2025, updated July 31st, 2025. ESPN, so this is after the settlement, which was from the article that I read on July 18th from the New York Times. So this article says ESPN has cut ties with NFL Hall of Famer and media analyst Shannon Sharpe less than 2 weeks after he settled a lawsuit in which his ex-girlfriend accused him of the R word. Sources briefed on the decision told The Athletic on Wednesday. Sharpe has not been on ESPN since late April when the suit was first filed. He said at the time that he would return to ESPN at the beginning of NFL training camp. ESPN declined to comment. Scrolling because we talked about this. And then I don't know if you heard that when they announced his departure, he has an older brother whose name is Sterling, who's a five-time Pro Bowler for a five-time Pro Bowler for the Green Bay Packers. I didn't know that. Will be inducted to the Pro Football Hall of Fame on Saturday. So basically, he wanted them to wait to make the announcement. He knew that this was going to be salacious news that ESPN was firing him. They said, "Negro, please," and they fired him. So bringing it back, Shannon could have felt pressured to settle by the start of the NFL training camp, which is late July. It says, with most teams having their rookies and veterans reporting around July 22nd, the earliest report date is July 12th for the LA Chargers rookies. The Falcons and Pittsburgh Steelers will be the last to report on July 23rd, according to USA Today. So that means that, and that makes sense if he settles with the girl around July 18th, because that seems to be around when NFL training camp starts and when he would have expected to return to ESPN, which makes sense. He's a commentator, so that would make sense that he would return at that time. And ESPN fired him on July 30th. So Shannon might have felt pressure to, like, all right, I got some money, or I got it one place or another, and decided to settle the case. So here I'm putting on my legal hat. Like, settlements and is all about negotiation. You have to know your strengths. You have to know your weaknesses. You have to know the strengths of your case. You have to know the strengths of the other party's case. You have to know your weaknesses. You have to know the other party's weaknesses, because that's the only way you'll really be able to. And this is negotiation just in general. Even like, for example, you're trying to buy a car. If you got no credit, you ain't got no money to put down, and you are desperate, you're going to take what you can get, right? So you always have to know the position of the other parties. And so what I think happened with Shannon was like, okay, I'm up against this deadline. I already, at the time there had been audio released from BuzzFeed's camp. His attorney already said we already offered her 10, so she's getting at least 10. So, and then he's up against this deadline. I feel like he just felt like, I can't drag this out to a trial. He might have known, trials take a very long time to get started. The lawsuit was filed, so service wasn't an issue, but to get court dates, to do discovery, if they were going to have a jury trial, like, all of that stuff takes a lot of time. And if he felt like he had 2 weeks to get all this together, then I can see why. Or 2 weeks, a month, 2 months. He knows all that's not happening. Let's say April to July. So 3 months. He knows he knows he's not going to nobody's trial in 3 months. So his best option was settlement. So for me as an attorney, and if you are an attorney watching, you really have to know your strengths. So I wanted to weave in some anecdotal stories. I remember when I used to work in housing court, this is probably like my best nigga, one of them, because your girl is good at it, okay? And I had a client who, in housing court, it's all negotiation. People are either trying to pay their rent, or they're trying to get money to move. They're trying to have money waived for whatever they owe, like if they move out by a certain time or whatever, or can they have time to pay? Like, there's so many things that kind of go into it. So I had a client, I don't remember why we did this, but my client had the right to a trial. So I was talking to the attorney. I was trying to give her as much time as possible to pay off the balance. And he was like, now, he was such a D-head. And he was like, no. And I was like, well, our earliest, trial date at the time was like November. Let's say it was like 3-4 months away. And I was like, if you won't give her until that date to pay, then we're going to ask for a trial date. Then that means the trial date has to happen. Anything can happen. The judge could be out sick. It's November. That's flu season. That's COVID, the height of COVID season. That is their car wouldn't start, so they clearing off their calendar. You got to come back in 2 more months, and the attorneys know that. So I was like, you can either agree to this date, and because I knew that the next trial date wasn't until November, I was like, we can either agree to this date, or we're gonna ask for a trial. Anything could happen on that date, but even if we do, that means you still have to prove your case. That means that the judge, they usually write a decision. Sometimes they take a while, sometimes they don't. We don't know. So, and I was like, and then you may lose, or you may not even get all of the money that you're asking for. So right now we're offering that to you. We just need time to pay. So it's up to you. Y'all, when I tell you he was heated, but I was like, we went in front of the judge and we wrote up that settlement agreement, and he was a little about it, but he even made a comment like, oh, this is not how we're supposed to negotiate stuff and blah, blah, blah. And I just sat there like, but you agreed to it, so what's up? So that's what I'm saying. You have to know your strengths and your weaknesses. Like, negotiation is really about strategies. I'll also say too, as far as like settlements and suing, it's important that you know what you want. So for example, going to the lawsuit with the girl, or the woman in Chicago, and she sued for $20 million. It was a $20 million defamation lawsuit. She sued for $20 million. That girl may be like, so the fact that her case was dismissed with prejudice as well. Okay, I had to get the facts, child. This phone's gonna be my best friend, Lord Jesus. Okay, so according to frontofficesports.com, there's an article dated August 8th. Oh, it was a couple days ago, 2025. And this says Shannon Sharpe and his legal team has settled their second multi-million-dollar lawsuit in less than a month. A $20 million suit against Sharpe, nightcap talk show partner Chad Ochocinco, and Sharpe's Shay Shay Media from Jamalita Tillman was dismissed with prejudice by a U.S. District Court in Illinois, according to court documents. Okay, so again, we already know what dismissed with prejudice means. I kind of don't like the word dismissed if the plaintiff is withdrawing it. So whatever, that's just like a pet peeve of mine. Like, it's because like dismissed means like the judge is making the decision. If I'm withdrawing the case, then it's withdrawn with prejudice. You know what I'm saying? I don't know. I mean, maybe someone could make that make sense to me, but that happens a lot. Or that happens, and I just don't like it's tomato. Kind of, sort of, not really, because I think words matter. But anyway, so what I do think is interesting about that dismissal with prejudice, which again, what class? It means you can't bring it again. Is that, because, I know there was another article that talked about no court fees or costs being awarded. I'm like, there's no way I would walk away from that suit with no money. Because even to file a case costs money. And in Chicago, I know it's expensive. I have personally filed a small claims case in Chicago, and it's over $300. So just to file. Then you have to have the person served. I elected to have them, you're able to do it via certified mail in Chicago. But I'm like, I'm not going to be out just $300. Like, I at least need my $300 back. So I personally think, without knowing these people or anything outside of what I've read online, I think she got something. It may not have been $1 million. It may have been 10,000. I don't know. She might have been happy with that. I don't know. But I don't think she withdrew it and got nothing. That to me makes no sense. It got so much media attention. I don't see her walking away with nothing. So I think they offered her something. And then with defamation and libel, you have to show.
So I'm not sure what section she sued them under for her case. I didn't look it up because it's been withdrawn, and so it kind of doesn't matter anymore. But this is a section that I found that I think could be applicable. So that's why I just wanted to put this blurb in here to show why I don't think she walked out of here with nothing. Because just what this is saying, it says that if any person shall falsely use, utter, or publish words which in their common acceptance shall amount to charge any person with having been guilty of fornication or adultery, cheating on your husband, getting a divorce, such words so spoken shall be deemed actionable, which means she can take action and sue him, and he shall be deemed guilty of slander. So I highly doubt she walked away with nothing.
Maybe they were like, well, maybe you can't prove that. I mean, she can, because if they said she was married and she wasn't, that's easy to prove. So then the burden would shift to them, where they would have to show that that either that it was true, which they can't, or I mean, I guess they could try to show that it wasn't reckless, but then they would have to show something to make them think that she was married. And it's like, even if I wear a ring on my ring finger, to say that you were married and then you got divorced because of that, I think that would be considered reckless. So I don't see her not walking away with anything. I think she had enough to say, hey, I'll withdraw it. I'm not going to, like, it don't have to be 20 million, but I'm leaving here with something, right? So that's what I think happened with that one. I feel like I get a lot of questions as an attorney from people. They're like, oh, something happened, someone owes you money, what do I do, blah, blah, blah. And honestly, I always tell people the only way you're going to get people to respond is to sue them. I'm definitely, I would never, and I'm not encouraging like frivolous lawsuits or just like filing just to file, because again, it can cost you money, right? Like if someone frivolously sued me, I'm asking for, damages to have to defend the lawsuit. I'm asking for attorney's fees. I'm asking for filing fees. I'm asking for it all. So I would only suggest someone filing a lawsuit if they feel that they have a, valid claim. But outside of that, hell no. But if you do, then, that's the only way to get people to do stuff. Even with the demand letter in the Tillman ladies case, she sent them a demand letter to say, hey, can you take this down? And they didn't. And, they only responded when they filed the lawsuit. Like, that's what you have to do sometimes for people. So, or two people, in order to get them to respond and try to do what, or attempt to do what you want them to do. So I think that's important for you to know. I would also say too that if you are someone, like, for all my attorneys out there, I think that we are in a good position to sue. And hear me out. Again, teachable moment, anecdotal story. But one time I had my car that I have now, I had it for like 2 weeks, and this valet person scratched my car. So I was like, it wasn't a big scratch, but you still scratched my car. So I reached out and I said to whoever I need to reach out to, and I was like, hey, y'all scratched my car. Like, I had a picture in front of my car when I got it. So I'm like, this is a brand new car. I can show you the title. Like, and you can't prove that it was scratched when I dropped it off to you, because I know it wasn't. So, hey, can I have your insurance information so I could go through your insurance? I wasn't asking them for money. And they were like, no. They tried to say that it was there before. And I was like, show me. They had some video. And I was like, girl, please. So I filed the small claims because I was like, I want my money to be able to fix the scratch on my car. Like, I know how much, auto body stuff costs. And this car is brand new. It still has the new car smell. So I think that was the very first lawsuit that I ever filed on my behalf. And I don't remember. But they did reach out. Or they sent me a letter basically saying like, basically trying to threaten me, say like, this was like a frivolous suit. And if you don't withdraw it, like, we're going to file for like attorney's fees and all the other shit. So I called the number on the letter that they gave me. I called their attorney and I was like, what's up? Like, I'll withdraw it, but like, y'all scratched my car. I have proof. Like, I'm a lawyer. Like, I know what I'm doing. You know what I'm saying? So I was just like, no, I have proof. Like, I'm not making this up. Like, it's not an old beat up car. No, this is a white car and I can see when there's scratches on it. And so he offered me $500. I was like, please, no. So we took it to court. We went to court and there were two attorneys and the judge was like, what? And then in this court, because, I practice and I knew the judge and I was like, oh my God, this judge is such an a-hole. And he's just so like volatile. Like, he could be pleasant when he wants to be, but when he wants to be an ass, he is an ass. So, Lord Jesus, have mercy. So I was just like, I don't know what to expect. And that's also the benefit of being an attorney when you are, if you do find yourself like needing to sue someone, is that especially if it's in the court that you're practicing in, like, what to expect, what to do, what to do not to piss them off, who's gonna, what I'm saying? Like, you just know that's an advantage that you have. And so I didn't know how he was going to be. So remember, they offered me $500. So we get up and, obviously the judge recognizes me, but he's like, well, what's this case about? And I said, I explained it. I had this scratch on the car, blah, blah, blah. And then they were like, so for context, I was suing for $2,000. So, because that was my estimate with like, when I went to like an auto body shop, how much it would cost to have it fixed. And they were like, well, Your Honor, we offered her $1,500 and she didn't take it. And I was like, I think that was my face. So I was like, hell yeah, I would have taken the $1,500.
I just want to clarify, too, that when I mentioned the letter that I got, so I sued the valet company, and the valet company, they either will hire someone they will have someone who's in-house counsel, which is like someone who works for them, or they'll have like an attorney or a law firm on retainer. So when I got the letter, I reached out. I don't know what the relationship was with the valet company, but so when I got the letter, it was from their attorney, not the valet company directly. Just wanted to make sure that was clear. And then, so now the reason why I'm saying I would have taken the $1,500, even though I sued for $2,000, again, because number one, you always ask for more than what you think you're going to get. And number two, just going to court is stressful. I had to like take off work or, just like rearrange my day. I don't know how long I'm going to be in court. And just having to go is stressful. And again, like I showed up. I was the only one there by myself. I'm going against 2 attorneys. I'm in front of this judge who I know is difficult. So that's the reason why it's like if they would have been like, here's $1,500. Honestly, I would have taken $1,000 to be perfectly honest. And that's why I say you have to know like your other... To just like avoid everything, like I just probably would have taken $1,000. But I'm like, now that I had to go through the trouble of going to court, no, now I want more money, So I explain that next. But that's why I'm like, hell yeah, I would have taken the $1,500.
I say, Your Honor, this is the first time there's like, I don't even know if I said it like that. I was like, oh hell no, I didn't say that. But I was just like, Your Honor, they never offered me $1,500, and he was like, well, they offering it now, so y'all go ahead, go outside. Do y'all little negotiations, because again, the courts don't want to be bothered. So we went outside, and so now that I know they tripled their offer, I was like, no, I want $2,000. So they were like, no, blah blah blah, and I said, look, we're already in court, we already here, like I might as well get my experience. Like, what you like? No, I have nothing to lose. So they went back to their people and they came back with $1,750. So they went up from $500 up to $1,750 from $500. And they had made a comment too. Well, like they were like, oh, because I didn't know these people. They were like, oh, well, how much are you charging per hour to be here? Like, trying to get me to just take the $1,500. I said, sir, I'm an attorney. This is my car. This is my case. Like, I'm not paying nobody nothing to be here. Thank you. So, I got my $1,700. They paid me out in 2 weeks. That was part of the settlement agreement, and I was happy, and they were like, oh, a negotiation and a settlement negotiation, no one walks away completely happy. And I said, I think that is a fair assessment. So for my attorneys out there, don't be afraid. Again, I'm not encouraging anything frivolous, but if you need to sue a motherfucker, sue them, okay? Do what you need to do, because if you have been wronged and you have proof, do it. So, my last story that I think will be, or my last point that I want to make that I think will be relevant for you guys is like personal injury cases. So I have friends who have come to me for personal injury like questions, and it's important to know what your negotiation power is. So remember, I want you to remember a few things. Number one, you are the client. So if you have an attorney who's like encouraging you to settle and you really don't want to settle, like, no, that's their job. Like, they are supposed to, as attorneys, this is literally our job. If you want to take it to court, we can advise you one way or another, but you are the client. You listen to their advice, right? Don't be afraid to get a second opinion, but you are the client. Advocate for yourself. Advocate for what you want. If you need to bring someone else in, you got a lawyer friend like me, bring me in. Like, yo, Denny, I'm about to have a call. Can you jump on the call? And I can talk to them. Like, what's up? Like, why? Or, and someone like me could even be like, okay, I kind of understand. Okay, what evidence do you know that they have? Like, I can make that assessment, for someone to be like, nah, you bugging, or have you thought about this, or whatever, right? So you are the client, advocate for what you want. Number two, the personal injury, like car accidents, stuff like that. I know 2 people right now who are going through something like this, and where someone was hit by a car, and my friend was like, yeah, they're offering like $30,000. Damn, I'm supposed to do the math. They're offering like $30,000, and we know that pre-trial or like pre-filing, depending on the company or the attorney, they charge, or they take, there's no upfront cost, but they take a third or 33 1/3% from whatever you get. So I think it was $30,000, and I'll do the math now. So he was like, they're offering 30, and I was like, well, how much do you want to walk away with? Because whatever you want to walk away with, you need to then work backwards to calculate that, to see that after they get their cut that you get what you want, right? So for example, so for if his settlement was $30,000 and the attorney got let's just keep it easy, 30%, right? He'd walk away with $9,000. Not really doing that much work. If you're just negotiating back and forth, like $9,000 is not bad for not going to trial, right? So, and I said, yes, going to trial can be tricky and, it's sometimes a gamble, but I know sometimes attorneys don't want to go to trial because it's a lot of fucking work. I will be the first to tell you, going to trial is a lot of work, depending on like the facts of the case, any, complexities, anything like that. It's a lot of work. So, I can see someone being like, oh, let's just settle for $30,000. It's something that's guaranteed. They get their, 30% and they're good to go. Versus if they were to go to trial, let's say they only get $20,000, right? So if you do the math for that, even if they go to pre-trial, it's 30%, going to trial, it's 40%. And so if they only get 40%, then they get $8,000. So it's like they did more work and are getting less money. So I was like, yes, it makes sense that they want to settle because they're not doing any work and they're getting a third of what you're getting for no work. To me, that's why it makes sense why they would want to settle. So that's why I was just like, you need to push a little harder, because if you want to go to trial or if you want more money, you need to work backwards. Think about whatever number that you want. And if they settle what, so I think he said he wanted, let's say 50,000. So I was like, okay, you need to get 75,000 so you can, because, let me just make sure my math is right, y'all. So, because if they take 75,000, he gets 70%, 52,000, whatever. You get what I'm trying to say. You just got to work backwards. Whatever you want, do the math. So, so I think that's important too. It's also important to know like what the limit is of like an insurance policy, because that's what what you'll have to work with. So again, another friend was telling me that she knows someone who was bit by a dog. And so the first thing she said as well, because she's an excellent attorney, she was like, well, what's the insurance limit? Because that's what we're going to be working with. So they first offered him like $10,000. And she was like, absolutely not. You got bit by a dog, like you have scarring. Like, no, they need to go up. I think right now they're up to 75,000. But like, that's another thing. That's why you have to know, number one, what you're working with. And then two, negotiate from there. Because if let's say the policy is $100,000, no, I'm not taking $10,000. You're going to have to come up more than that if we go to trial. So no. Or it's going to cost your attorneys more. Like, people at the end of the day are doing calculations for their money and for their time. So I think that's that's another important thing to remember. And then even in like med malpractice, it's the same thing, which is kind of like the dog, but I guess that is more personal injury. But so shout out to Simone Redwine, because I follow her and I watch her videos. Something that I didn't know that I learned from watching her videos is that sometimes insurance policies, just like car insurance, doctors have med malpractice insurance. So if something happens, you could still, and again, if something actually happens to you, you could file a lawsuit and be like, okay, well, you should have medical malpractice insurance, and and then negotiate from there. So that's why I think it's important to like know these like little tips and tricks, so that when you are talking to your attorneys, number one, before you hire them, that they know what they're talking about. And then number two, that you got to look out for yourself, especially because you're the one who's injured. You're the one who needs compensation for what someone else did to you. So yeah, that's how I would do it. I hope this is helpful. I was trying to keep this as short as possible. Again, we'll be back next week. I'm going to put up another poll, maybe Friday, a little bit earlier, so I have a little bit more time to prepare and all that other stuff. But be sure to like, follow, and subscribe. Leave any questions or comments down below. And I'll see you next week. Later.